would like first to introduce what is our organization, our association UJUB. I would like to explain the rationale, the goal of this mock trial. I would like to express my gratitude, my thanks to various organizations. And then in the end, I will give the floor to the registrar, Dominique Ménard, who will introduce the judges and the parties. UJUB, in fact, I don't know how you pronounce that in English, is an association which has been formed a few years ago by most of the patent actors, patent players in France. It includes the enterprise from MEDEF, where we are today, Mouvement des Entreprises de France, AFEP, which represents the big enterprise in France, and CGPME, which is an SME organization. It also includes the Attorney at Law, the Paris Bar, and as you know, the litigation in terms of patents take place in Paris, in France, and also the API, which is a specialized IP, Attorney at Law, avocat organization. The patent attorneys, represented with respect to the firms by the CNCPI, la Compagnie nationale des conseils en propriété industrielle, with the President Alain Michelet, and ACPI, the Patent Firms Organization, and from the industry side, the ASPI, l'Association des spécialistes en propriété industrielle from the industry. The association also includes many IP associations, such as AIPPI, the French group of AIPPI, APEB, Association des professionnels en brevet, Licensing Executive Society France, LAS France, AFPPI, Association française de la protection de la propriété industrielle, and the ACPI, the Friends of the CPI, the organization which gathers all those who have been studying in CPI in Strasbourg. Paris, and I think UJUB played a role there, has been designated as being the seat of the central division of the new court, together with clusters in Munich and London. And of course, Paris will be also the place for a local division. For us, this court is, maybe to be strict, I should say will be, but is already a reality. It's a fact, and we have to be prepared. We have to know what's new. We have, from the enterprise, from the attorney at law and patent attorney side, be ready to act before this court, which will play a major role in Europe. This court is a European court. It's not an EU court, but it's a European court. And this is why we decided to make of this trial a European event. And this is why to have this mock trial being run in English. And I think the UJUB would also like that the local division in France accept 2 or maybe 3 languages, English, German, and French, because we are all European and we have to play a role in Europe. Another goal of this mock trial is the rule of procedures. You know that there have been many versions of the rule of procedures. Without knowing much, but I think it was understood there would be a hearing on this rule of procedures. And today you will have a case where you will learn, you will see how it works, and you might have better ideas to answer the hearing or to make comments when time comes. I would like to express my gratitude to those who made this mock trial possible. First, our sponsors. You have seen their names mentioned in the organization, the invitation to the mock trial. I would like to specifically mention 3 sponsors. One is APEB, because APEB was the origin of this proposal. And after I've been studying the question, it thought it was better that it would be given to UJUB to run it. The second one is MEDEF. As being from the industry, I wanted to do that, but also because MEDEF has been giving us this auditorium to run the case, and also because to me it's a sign of the importance of FUJU beyond the legal questions. The unitary patent and the court are tools for competitiveness, are tools for growth and creation of jobs in Europe. So I think this is what we are talking about, in fact, whether you are judge, attorneys, lawyers, or from enterprise. I would like, last but not least, thank very much the French Patent Office, the INPI, who since the creation of FUJU has played a major role in helping us with many respects. I would like to express my thanks to Valérie Hocher, who represents Yves Lapierre, the Director General, and Fabrice Clairaut for their presence. They played also a major role in sponsoring this event and also in helping us informing the French authorities of what should be done. And in fact, you should know that all over Europe, apart from the other actors that you know, we have been inviting, and they said they would follow, the European Commission, representative of the Preparatory Committee, representative of the European Patent Office, OHIM, all of them will follow the case. Today, there will be something particular, at least with respect to certain law, and more particularly French law. In this case, the presence of a juge rapporteur and the role of this juge rapporteur, which is something new, at least to us French. This is one of the differences that we will experience in this new court. There are other differences. One of them, at least also comparing to France, is the possibility to patent attorneys to represent clients. We did not have time to do it this time, so the organizers, the members of FUJU, decided to run another mock trial before the end of the year, incorporating patent attorneys in the case. I think it's now time to give the floor to the judge because we have a tight schedule. I would like to ask Dominique Ménard to take the floor. And as we are today, the day where our Dutch friends, colleagues are voting, and we will vote on Sunday with respect to France, I would say, vive l'Europe. Thank you very much.
And if I may say so, as we have a colleague coming from the United Kingdom, I would add, God save the Queen. It's a great pleasure and my honor to be here. I'm so happy to have been promoted as a registrar of this court. It's a new period of my life, but probably a short experience. So I wouldn't like that my colleagues, members of the Paris Bar, be totally desesperated. I can say them, don't worry, I'll be back. Let me introduce you to you, Mr. Grabinski, Dr. Klaus Grabinski, who is nearby me, alone, due to the fact that he was in charge of the preliminary step of the proceeding, and he was, and he is, the juge rapporteur. This is the sole reason why he is here nearby me alone. But we have in this room the panel who will deal with this case. Dr. Grabinski is very well known as a member of a judge of the German Federal Court of Justice. In Germany, they used to speak about Bundesgerichtshof, and he started his new period of career in 2009, if I'm right. He was before presiding judge at the district court in Düsseldorf. He is an expert in the patent field, in the civil law, in the patent field mainly, and he has written and signed many commentaries which have been published, and is recognized as a very high-level, top-level expert in the patent field. He will be sitting nearby the presiding judge, Mr. Alain Girardet. Of course, most of you know him. He started his career as magistrate in 1978. He served at the beginning of his career the Ministry of Justice, being at the top level of information and business, organizing this ministry. And all the practitioners had the pleasure to work and to plead and to argue in front of him when he was from 1995 to 2005 presiding judge of the First Instance Court, the third chamber section of the First Instance Court in Paris dealing with IP. Then he joined the Court of Appeal and now is a member of the French Supreme Court, Cour de Cassation. And it's always a pleasure to see Mr. Girardet, who also is recognized as a very, very top-level expert in the patent field. He signed many, many articles and comments, and he was recently appointed by the OMC and some other international institution, to explain to the foreign countries how it works in the patent field and in the law. So we are very pleased to have Mr. Grabinski, to have Mr. Girardet, and a new experience for the French lawyers, to have on board, if I may say so, Mr. Walter Holzer, who studied law in Vienna, which is not so surprising because he is from Austria, and is graduated from the Technical University in Vienna and Mechanicals Engineering. Mr. Holzer used to be for years a lay judge, a technician judge, which is classic and normal in Austria. So he has a long experience of this type of debate as a member of a court. And so we are very happy to have him on board today. And two words about my, not my colleagues, my past colleagues and future colleagues. Michael Burden, who is representing the claimant today, is coming from London, but before to be in London, he made a longer trip from Australia, because he was born in Australia, and I'm not sure that he's totally living in London. I think that part of him is still in Australia, and probably his heart is in Australia sometime. Michael is a patent trial lawyer, is a solicitor in London, but he likes trials. He's recognized as a very good specialist. As in France, classically, he deals in many fields of technique issues, pharma, electronic, and is a good professional, and he was described by IAM as a leading patent litigator. So you will have the privilege and the pleasure to see our friend Michael, working today in front of you. And to end this introduction and presentation, my friend, before to be my colleague, my friend Pierre Véron, how to say, is a master, is our star, is our international patent trial lawyer traveling all around Europe to demonstrate that some lawyers knows about patent, and is one who knows perfectly well about patent. Pierre started his career in 1969. So I must stand up because I started in 74, so you have my respect, my dear. He created the cabinet Lamy Ribert Véron in Lyon, and I never told you a secret. Lamy is a cousin of mine. And in 1996, he wanted to climb to Paris. We say climb to Paris in French, on monte à Paris, to be a member of the Paris bar. So I saw him arriving from Lyon. And he started his own law firm, Véron and Partners, in 2001. He's a brilliant lawyer, he's a fair lawyer, he's a clear lawyer, he's a charming person. And it's really always a pleasure and a good news when our clients sometimes say we have been sued, and the lawyer in front of you will be Pierre. And for us, it's always, oh, we're lucky. He was president of the AAPI. He created the EPLO, which is a huge, very recognized international association. And he had made many, many publications. He's an expert for the Europe for the UPC. So we are lucky to have him on board today. And now, as I'm not sure to stay many years as a registrar of this court, and due to my age, I thought it was reasonable to have a deputy registrar. And I have the pleasure to introduce you my associate, Jules Fabre, who will continue the real work, because in fact, I made nothing.
Thank you, Mr. Registrar. I will now make a very brief presentation of this case for the understanding of the audience. The case which will be dealt with today pertains to the alleged infringement of a European patent with no unitary effects. This patent was initially filed by a US company named United Video Programs in 1995 and with a US priority from 1994. The patent is entitled Method and Apparatus for Accessing Information About Television Programs. The alleged invention relates to a system of providing on-screen information about TV programs, which is also called an electronic program guide or an EPG. As you will see on the map which is displayed on the screen, the claimant is a Dutch company named Telecast BV. And there are 4 defendants from 4 different states. The first defendant is French. It's a company named Blue Cable France, and it provides its subscribers with a set-top box that enables to receive and record TV programs. These set-top box integrates a so-called EPG. The second defendant is a German company, Blue Cable Germany, and is a sister company of the first defendant and has basically the same activity. The third defendant is incorporated in Switzerland and is named TV Grid Switzerland. This company developed the EPG, which is integrated in the set-top box marketed by the first and second defendants. And finally, the fourth defendant is an Italian company, TV Grid SPA, and this company provides the EPG to the first and second defendants. The claimant considered that the set-top box marketed by the Blue Cable companies and the EPG developed and provided by the TV Grid companies was infringing claims 1 and 2 of the patent in suit. Therefore, Telecast brought an infringement action before the Central Division of the UPC against the defendants. consideration of the technical field of the invention at stake, the electricity section of the UPC, whose seat is located in Paris, was being attributed the case. During the interim procedure, the defendants lodged preliminary objections challenging in particular the jurisdiction of the Central Division for some of the defendants. These preliminary objections were discussed, among other issues, during an interim conference and dismissed by the judge rapporteur by way of an order which was served upon the parties. This order granted a leave to appeal with regard to the issue of jurisdiction, and the defendants lodged an appeal against this order. This will be exposed into more details after this preliminary presentation. The defendants are requesting a stay of proceeding pending decision of the Court of Appeal on the issue of jurisdiction of the Central Division. And in reply, the defendants have raised inadmissibility issues, arguments, and have lodged a counterclaim for revocation of claims 1 and 2 of the patents for lack of patentability, lack of novelty, and or at least lack of inventive step. And they also denied the alleged infringement. I will now leave the floor to Mr. Registrar Dominique Bénard, who will introduce the interim conference which was held by the judge rapporteur.
Yes, 2 words to explain you what happened on the 29th of April. In accordance to the rules, an interim conference took place on this date and was handled by a video conference, and this video conference was registered. As you can see on the slide, the audience was set up between Düsseldorf, where Mr. Judge Rapporteur Klaus Grabinski was staying, between London, where Michael Burden was staying, between Lyon, where Pierre Véron and Mrs. Métier, counsel of the defendants, were standing, and at least between Paris, where I was standing. A video recording of the interim conference was made and is available. The registrar communicated to the parties minutes of the interim conference, as expected, and this recorded conference is made publicly available and shall be binding the parties. Mr. Grabinski, would you like to start the presentation and to explain, to say a few words, or we will start by the movie?
Yes, peut-être j'aimerais bien profiter de l'occasion de, avant de parler dans la langue officielle de notre procédure, de dire qu'il me fait grand plaisir de participer dans cette, oui, comment on dit en français, audience et le mock trial et surtout parce que ça c'est au siège principal de future division centrale à Paris. Bon, après avoir dit ça, je parle maintenant, je continue en anglais. Yes, the idea is to show to you parts of the interim conference that was recorded on video, and you see different sequences of this interim conference, and after this part there is a time for discussing aspects or issues you would like to raise. But this video is only covering the discussion on the preliminary objections, and is also covering the final decision or the decision by the judge rapporteur on the preliminary objection. And there was a second part dealing with case management questions. There is no video on this one, but I will give a short report on what happened, and then again we have a little time to discuss this.
Okay, can we have the movie?
Good morning, welcome to the new European Brave Patent World. This is going to be the first interim conference in a mock trial according to the agreement on UPC and the rules of procedure on UPC. We have present in this video conference representative of a claimant, Mr. Michael Burden, is this right?
That is right, and it's a great honor to be present at this magnificent occasion.
Thank you, Mr. Burden. And as representatives of defendants, we do have Mr. Pierre Véran and Mrs. Amadine Métier, is this right?
This is absolutely right.
And we are also joined by the registrar, Mr. Dominique Ménard.
Yes, I'm deeply happy to have been promoted as registrar of this court, of course.
Thank you very much. The schedule of this morning is going to deal with two issues, essentially. The one issue is preliminary objections, which have already been filed in written form. Normally, it is my view that the judge can decide only on the written basis, but since it's the first case we are dealing with, and since there are still a few questions I would like to ask to the lawyers, I would like to deal with the preliminary objection in this video conference. And the second part is going to deal with some management questions, essentially preparing the oral hearing that is going to be to take place in about 1 month in Paris at the headquarters of the Central Division. So let me please first start with dealing with the preliminary objections. And as you probably know is that the judge has very thoroughly studied your written statements, the preliminary objections of Mr. Burden on the one hand, and the reply of Mr. Véran and Mrs. Métier on the other side. And before giving you the floor, I'd like to raise a few issues. The first point that was made in the preliminary objections is whether the court is competent under Article 33, paragraph 1b to deal with this case. After having read the objection, I think there is no doubt that the court is competent to decide with regard to defendant 3, who is a company located in Switzerland, and so it's located outside the territory of the participating member states. The question is whether the court is also competent with regard to the other 3 defendants who are located in member states, in participating member states. So this is the first point. Second point is that the defendant also requests that the case should be, that the court should decide that the case should be brought before the Italian division.
I do not see a legal basis for this request. So please, Mr. Véran, Mrs. Métier, could you explain on what legal basis you are requiring the court to make this declaration? I see only a basis for a transfer with regard to Article 33. Article 33, paragraph 2, subparagraph 2, but this is clearly not the case we are dealing with, since this is not a case before a regional division, it's a case before the central division. So the next point that has been raised in the preliminary objection is, to my understanding, not a preliminary objection, because preliminary objections are exclusively dealt with in Rule
19.
In Rule 19. In Rule 19, thank you. But the question that is raised here is dealing with entitlement and ownership of the claimant with regard to a patent assignment. So my view in this context is that this is a request under Rule 334H rules of procedure and not a preliminary objection. I also would like Mr. Véran to deal with, in this context, to deal with the question whether claimant is entitled to bring forward claims is not only a question of patent assignment, it could also be a question of whether the patent owner is registered as patent owner in the National Register. So please could you also deal with this question. Next point is about whether a claimant would be entitled to execute his claims with regards to a French provision in the French law. This is going to be Article L 613(9) of French Intellectual Property Code. In this context, I would like to ask a representative of the claimant whether he has filed an application for registration of the claimant as new owner in front of the French National Patent Office. He hasn't given any indication up to now, or is he still waiting to file to be registered as owner before the French Patent Office? And the last issue that has been raised in the preliminary injunction is dealing with the question whether defendants should be provided with translations of all relevant documents into 4 languages, namely French, German, Italian, and Romansh. Again, I do not think that this is a question of preliminary objection. This is more a request under Article 51, paragraph 3 of the agreement. And in this context, I'd like to explain, I'd like to have the representative of the defendants to explain a bit more what is the regular language in which defendants are communicating among each other. So what is the language that they are using in practice? I also like to remember a representative of the claimant, of the defendant, that in the particular area of technology with which we are dealing in this case, namely broadcasting services, normally the language there is English, if I'm not mistaken. So please, could you explain why defendants are using another language in their regular commercial life? So I raised a number of issues. I would like to invite lawyers, representatives of claimant and defendants, not only to repeat what they have laid down and explained in their written statements, but also to address the questions I raised now.
I would be grateful for the court's indication as to whether the defendant's preliminary objections are indeed admissible, given that they were filed in the French language and not in the language of the proceedings, which caused me some inconvenience, not being a French speaker. My language ability is limited to 3 dialects of the dominant English language, Australian, British English, and occasionally American English. The language of the patent is clearly English. The language of the statement of claim was English, and it follows, in my view, that the preliminary objections should have been filed in English, not in an alternative language. And as this is a preliminary point which, if the judge appreciates the force of the point, is successful, then there is no need to consider these other subcategories which you have just identified.
Yeah. May I ask you, have you been provided by a translation of the preliminary objections in English?
No, I have not.
But were you able to understand, or did you have an internal translation of these objections?
I have, with some difficulty, inconvenience and expense, been able to understand the general force of the arguments put forward by Mr. Veron and the defendants.
Okay. The point of view of the court in this regard is that, of course, you're entitled to the right to be heard and to be fully available to respond to all the points that have been made in the preliminary objections of the defendant. On the other side, I think it would so we could adjourn and give you some time to deal with these questions and to provide you with a translation into English, maybe even at the expense of defendants, but this will cost some time. So I think it might be in the interest of the claimant if you are able to respond, if you have understood what was in the preliminary objection, that we continue with this interim conference and do not put into risk the date of the oral hearing that is going to be in about a month's time. What do you think, Mr. Burden?
I am grateful for that indication, and I have no wish to cause any disruption to the proceedings. The claimants are anxious to obtain their just relief in these proceedings, and no doubt you, Judge, will bear in mind these tactical maneuvers by the defendants in regard to their other points that they have made.
Okay, Mr. Veron, you want to comment?
No, I just want to respectfully disagree with the judge rapporteur because Rule 19 of the Rules of Procedure, both in the 15th version and in the 16th version, do provide that the preliminary objection may be filed either in the language of the proceedings, and this is something Mr. Burden has probably overlooked during his vacations, but Rule 19, paragraph 3, B, letter B, is extremely clear. The preliminary objection shall be drawn up either in the language of the proceedings or in one of the official languages of the European Patent Office. This is simply, the drafters of the rules of procedure have been extremely wise and well advised, and they have considered that the objections should be raised within 4 weeks, which is extremely short. It's a pressure on the shoulders of the defendant. So if he is obliged to file the document in a foreign language in 4 weeks, it would not be fair. This is the reason why it has been provided that he may file in one of the languages of the European Patent Office, and there is no provision for any translation. Okay. So respectfully, I will not give any translation with Mr. Burdon.
Mr. Veron, you may have noticed that I was not saying that the preliminary objection is inadmissible. That was not what I've said. The only point I wanted to make is that claimant, that the right to be heard of the claimant is respected. So I wanted to make sure that claimant at the end of the day is aware of what is the content of the preliminary objections.
Okay, thank you very much, Mr. Judge Rapporteur. My preliminary objections are mainly about jurisdiction of the court, as you have noticed. And I think for the benefit of the people who could watch this recording afterward, may I refer to the drawing which has been enclosed in my preliminary objections, which shows that the defendant are belonging to 4 different countries, France, Germany, Switzerland and Italy. For the benefit of Mr. Burdon, who was not aware of that, Switzerland is not a party to the agreement. He mentioned in his pleading, inadvertently probably, that Switzerland was a party to the agreement but had elected not to have a local division. In fact, Switzerland is simply not a member of the agreement on a unified patent court. Therefore,
I think this morning we agree on this.
At the moment.
Yes.
So the issue turns about the longest articles of the agreement, Article 32 and Article 33. We shall certainly also agree that the court is seized with an action for infringement, therefore an action referred to in Article 32, paragraph 1, letter A. And the competence of the local division is then organized by Article 33, which makes a distinction and which opens options for the claimant. The claimant has an option under 33 paragraph 1 letter A to bring its action either in the local division of the place of infringement. He may also sue in the domicile, the place of domicile of one of the defendants. Let's read together Article 33, letter 2. The action shall be brought before the local division hosted by the contracting member state where the defendant, or in the case of multiple defendants, one of the defendants has its residence or principal place of business. And further, this article explains that when an action is brought against multiple defendants, there should be a connection between the defendants. So it is clear that we are in such a situation where the plaintiff has a choice either to bring the case in the place where the infringement takes place, and the alleged infringement, according to the plaintiff, is either in France or in Germany or in both countries, but not in Switzerland and not in Italy. And then, in our view, the case should be brought in, according to Article 32A, in either Germany, German local division, or a French local division. And under letter B, it should be either in the local division of Germany, the local division of France, or the local division of Italy, which, in our view, is the most appropriate to deal with the case, because it is the Italian company is the so-called spider in the web.
Mr. Veron, may I take the liberty, Mr. Veron, may I take the liberty to interrupt you for a second? At this point, I think the only point we have to discuss this morning is whether the Central Division is competent to hear the case that has been brought before the Central Division. So do you agree that we do not have to think about which could be an alternative competent local or regional division to go, but the only point is the Central Division competent to hear the case?
As usually, you are absolutely right, Mr. Judge Rapporteur, and it was only for the benefit of the education of Mr. Burden that I was explaining the content of Article Article 32.
Thank you very much.
Let's turn to Article 33, which is supposed to be the basis of jurisdiction of your court in the present case. I read the article. Actions against defendants, that's plural, having their residence or principal place of business outside the territory of the contracting member states shall be brought either in accordance with point A or before the Central Division. I'm convinced that you have noticed the difference of language between the paragraph about jurisdiction of the local division, which speaks about the defendant, or in the case of multiple defendants, one of the defendants. That's Article 33, 1b. And what I am reading is about actions against defendants, plural, having their residence or principal place of business. So my point is to say that the Central Division has only jurisdiction when all the defendants which are being sued are domiciled outside the territory of the member states. And in our view, in such a case, because the Swiss company is the only one domiciled outside, your court has jurisdiction only about the Swiss court and has no jurisdiction whatsoever for the other three companies which are the defendants, meaning the Italian, the German and the French one. And we must say that the court should decline jurisdiction as far as the French, German and Italian the companies are concerned, and it's only for the benefit of the plaintiff that we suggest that the case be transferred to the Italian local division, which is the so-called spider in the so-called web.
Just may I interrupt again, Mr. Veron? What is would be the legal basis for this transfer?
The wisdom of your court.
Thank you very much. But you agree there is no explicit legal basis for this, as it would be in the case of Article 33, 33 paragraph 2, subparagraph 2.
It's a wisdom of the court to fill in the gaps of the legislator, and we all know that the agreement has been drafted in some haste in some respects, and the case law of the court has to fill in these gaps. So our other arguments, you mentioned very cleverly, of course, that it was not a preliminary objections. It may well be that the argument of inadmissibility are not listed in Rule 19, which mentions as grounds for preliminary objection the jurisdiction and competence of the court, the competence of the division indicated by the claimant, and the language of the statement. So it's probably true that inadmissibility cannot be dealt with in a preliminary objection. However, my understanding is that we will have very shortly an interim conference for the case management, and in the framework of this interim conference, I am convinced that I am permitted to raise the issue of inadmissibility and to respectfully request the court, the judge rapporteur, to make a decision in this respect, because under Rule 334 letter H, the judge rapporteur has the power to dismiss a claim summarily if it has no prospect of succeeding. So I will share your opinion that probably inadmissibility cannot be raised as a preliminary objection, but it is just to put this point at the very beginning of the next hearing that you are going to organize about the management of the case, because I think you should dispose of the matter very quickly to avoid wasting the precious time of the court on a claim which is obviously inadmissible, because the claimant is simply not the owner of the patent. So end of the story.
Okay, so but let me ask you one question, Mr. Veron, in this context. I accept that, so you accept that this is not a preliminary objection, but of course we, the court might have to deal with it in the context of Article 334 H, rules of procedure. So if this is right, and then the question arises whether this, the point you made is really justifying to dismiss the claim summarily because it has no prospect of proceeding. What is involved in this context is a very difficult question, how to interpret the patent assignment agreement between plaintiff and the company, the former, this is not I should be, this is not the will be the company called United Video Programs, which has filed the patent and has been registered as patent owner. So the question is how to interpret this patent assignment, and don't you think that is quite a difficult question to decide, which should be for the panel to decide and not only for the judge rapporteur?
Is this a question for me, Mr. Judge Rapporteur?
Yes, of course.
Okay. So respectfully, I would say that there is no room for interpretation. It's just a question of reading. The court has only to read, if I may suggest, the patent assignment, which says that the rights assigned are rights about the patents which are listed in the appendix and the very patent at the suite is simply not listed in the appendix. So in my view, it's not a question of interpretation, but a plain question of reading and application of the agreement, the assignment agreement.
Okay, I got your point. Another question. We are not talking about entitlement, aren't we? And entitlement is not necessarily only depending on whether, on a material patent point of view, a patent has been assigned from one person to the other. It could also be another requirement in this context, could be whether the party has been registered as the new owner of the patent. For example, in the German law, and it would be that the first question is the person registered as patent owner? And the court would not necessarily, at least with regard to injunctions, ask whether there has been a legally valid assignment from one party to the other. So my question is, did you explore what law is going to decide on the question of entitlement? And did you explore, if it is national law, did you explore the situation in the four states that are concerned in this context, meaning France, Germany, Italy and Switzerland?
Of course, yes, Your Honor. We did explore the issue.
But you did not mention anything in your written statements on this issue.
I think I did mention the Article 24 of the agreement. It includes everything, right, because Article 24 of the agreement provides that the court will apply European law, the agreement, and when appropriate, national law. So this is in Article 24 of the agreement, and the very wise advisory committee to the drafters of the agreement had made the remark that it could be a good idea to be more specific on this issue, but eventually the drafters of the agreement decided not to go further. But it is clear that in Article 24, under paragraph 1 and letter E, the court should apply national law. But it is not specified in which case the court must apply national law. What is somewhat explained.
So what with regard to entitlement?
So I think entitlement.
What is your point of view?
Entitlement can be only dealt with national law. I cannot imagine that the court can make a decision about entitlement as far as the French designation of the patent is concerned under another law than French law. In the particular case, it is clear that the claimant has indeed registered his assignment in some countries, including Germany. So under German law and for the German territory, there is no problem, the situation is clear. But for France, the requirements of that specific article of the French Intellectual Property Code, which is Article 613-9, have not been met with, and this article remains applicable even after the entry into force of the agreement. In other words, the agreement supersedes some national provisions, for example, about the scope of the patent, what can be prohibited with the patent. But on all the points which have not been superseded in the agreement, then national law applies for the territorial part of the patent. So in my view, the court should apply French law for entitlement for the French designation of the European patent.
Okay, and so consequently your point of view is that the court should look to 4 different national laws with regard to entitlement, meaning for the Swiss part to the Swiss law, French part to the French law, German part to the German law, and Italian part to the Italian law. Is this your point?
It's my point. If the plaintiff, if the claimant wants to avoid that, he has just to file a unitary patent.
So we keep this in mind because up to now both parties haven't enlightened the court in this respect. So I would be happy to learn more about the national laws with regard to entitlement, maybe in future statements. But I will come back to this later in the conference. And now, finally, please, Mr. Véran, could you explain a bit more your point with regard to providing translations for the relevant documents? You know, there is in Article 51, paragraph 3c, there is one condition for providing parties with translations, and this is the defendant does not have proper knowledge of the language of the proceedings. So the language of proceedings is English. I think we all agree on this, and we are before the local division, and the language of the patent is English. So my question is, do defendants not have proper knowledge of the language of English, even having in mind that we are dealing with the technology, broadcasting services, where at least to the general knowledge, it is English that is the general language in this area of technology that is used. And secondly, I would like to know from you, Mr. Véran, which is the language in which the 4 defendants are communicating in the company, and don't they use English internally or when they are corresponding with clients? And I'd like also to remember you in this context that of course parties are obliged to tell the truth to the court, and I might request from you that if this is contested and if the court has doubts, that you submit affidavits and may even hear witnesses on this question. So please remind this when now answering to my question.
Mr. Judge Reporter, I understand from your comment that you are assuming that whatever company involved in high technology is supposed to be conducting its business here in English, meaning that in Switzerland any company dealing with communication and television should speak English, while companies dealing with Swiss cheese should speak only German? Is that your point?
My point is that you are obliged to give me facts that are supporting a condition that is laid down in Article 51, paragraph 3c. So you have to provide me with facts that defendants do not have proper knowledge of the language of the proceedings. So what are the facts you would like to submit to the court in this context?
How, from a very philosophic standpoint, if I may, how is it possible to prove a negative fact? To prove that I do not know English?
Yes, this is possible, at least in this extent that you show that parties have to communicate in a language. I think we agree on this.
Yes, but I am wondering whether...
by signs.
Whether the Convention on
so what
Human
is the language
Rights...
in which they communicate?
Yes. Is it compatible with the Convention of Human Rights that we are supposed to communicate in English because we are in the television industry, unless we prove positively that we cannot understand well enough English? Maybe the point could be dealt with by the Strasbourg Court on Human Rights.
Mr. Veron, with all due respect, I think you didn't get my point. The point is, what is the language in which parties are communicating, the defendants?
So, I want to broach with your point.
Is this the Romansh? Are they talking all in Romansh?
Okay. So, as mentioned in the preliminary objection, the Swiss company, which is the author of the process which is being accused, deals with and conducts its technical business in Romansh. And I explained the reason, because Romansh is one of the 4 official languages of Switzerland. This is in the constitution of Switzerland, and I do not permit that Mr. Burden loafs when I am quoting the constitution of Switzerland, one of my clients. And if you could invite Mr. Burden to keep all due respect to the Confederation of Switzerland, it would be a good idea. And so,
just to make it clear, of course, the court and in person the judge rapporteur respects the constitution of Switzerland, and this in particular on the background that judge rapporteur studied 1 year in Switzerland, so he is perfectly aware of the situation in this country. However, I'd like to come back to my point. Also, the Swiss defendant has to communicate with the other 3 defendants. Are you saying that the other 3 defendants are also speaking Romansh and they are all communicating in Romansh in order to keep technical matters confidential?
Yes.
And in which language do they communicate with regard to other third companies? Are they also communicating in Romansh with regard to third companies?
For all their confidential discussion, they use Romansh, of course. For business discussion, they may use some English, but their knowledge of English is very poor, and probably I'm the best evidence that their knowledge of English is very poor, because I cannot speak better English than my clients. So the court will certainly find that I'm living evidence that they cannot master English well enough to defend themselves.
In relation to the competence of the Central Court, it's clear that the wording in Article 33 provides that the Central Division has competence in relation to a dispute with multiple defendants where one of those defendants is located outside the contracting member states. And I do apologize for any confusion caused by the wording of the statement of claim, that in saying that the Switzerland did not host a regional division or a local division. Of course it does not. I was implying in that it was not indeed a member of the agreement at all, and pointing out the obvious when perhaps I should not have bothered to do so. It is clear from Mr. Veron's recent comments in relation to the Swiss-based defendant, the third defendant in the proceedings, that it is indeed the architect of all the business activities of the defendant's group of companies, and indeed is the spider in the web, if indeed that concept is indeed relevant to the proceedings and to the jurisdictional issues which this court must decide. However, in the claimant's respectful view, we don't need to trouble ourselves with concepts of spiders in webs and working out who should have the jurisdiction in relation to proceedings where there are multiple defendants. It is clear that one of the defendants, which is a proper defendant in the proceedings, is located in Switzerland. Switzerland is not a contracting member state, therefore the Central Division has competence. It is not a contest to work out which court or which division has the best claim to jurisdiction, but simply a case of whether the jurisdictional rules have been met. And I didn't hear any suggestion from Mr. Veron that the Central Court was not competent, at least in relation to the third defendant. He seemed to rely, if I could take the Judge Rapporteur to the third paragraph of Article 33b, to the reference to, in the third word of that paragraph, to defendants in the plural, and somehow suggested that a claim could only be brought in the Central Division if all defendants were located outside the, or were not a member of the, were not a contracting member state. Well, clearly that cannot be right, because that paragraph provides the jurisdiction in relation to a single defendant who is located outside the territory of the contracting member state. So there must be a degree of sensible and purposive construction applied to this paragraph, and it is clear in our view that provided there is competence in relation to at least one of the defendants, and that those defendants are in a commercial relationship, and that the action relates to the same alleged infringement, then the Central Division has competence over the claim. All the criteria are met, and therefore, in our respectful view, the Central Division is the right jurisdiction to hear this court. And that is both a matter... May I
interrupt you, Mr. Burden, at this point of time? You agree that the situation that there is are multiple defendants is only addressed in Article 33b, subparagraph 1, with regard to local or regional division. And this is not addressed with regard to central division in subparagraph 3. The court would have to fill a gap too, if I may take up the words of Mr. Veron. Either way, whichever way the court will go in this context, he has to fill gaps. So could you comment on this?
Yes. On my understanding of that third paragraph, actions against defendants refers to the situation with a single defendant and the situation with multiple defendants. There is a degree of filling in the gaps, but in my respectful view, the most sensible and appropriate construction and application of these jurisdictional rules is that, provided there is jurisdiction in relation to at least one of the defendants, and as I said, that they are in a commercial relationship and it is the same infringement, then the appropriate thing to do in those circumstances is for the Central Division to accept jurisdiction and competence. I think that if there is a gap, it is a very small gap and one which is easily bridged.
Okay, let's come back to the question of entitlement. Mr. Burden, what is what is your approach to the applicable law? Is this should national law be applied to the question of entitlement under Article 24, or what is your point of view in this respect?
My point of view is that the court should consider this in a stepwise fashion. The first step is to consider whether indeed this court should trouble itself with matters of ownership and entitlement. And indeed, the agreement and the rules are silent in my rather brief review, and no doubt Mr. Veron will educate me further if he can find reference to ownership and entitlement in the agreement and the rules. But that is a matter which is, if it is relevant, can be dealt with by national courts and between the parties. Indeed, the defendant has no interest in this question of ownership and entitlement other than to try and avoid the force of this patent. There has been no third-party claim in relation to the ownership and entitlement of this patent, and indeed that is something which this honourable court might choose not to consider. However,
may I interrupt you? But so what you are saying is UPC is silent on this question, but then I would conclude then I have to get down the line of Article 24, and it is national law that is applicable in this context. Wouldn't this be the logic?
My point is perhaps even more fundamental, which is whether or not the UPC should be considering matters of ownership and entitlement at all.
But if this is contested by the defendant, how could they say we don't care from the point of view of the court, or what would be the, since it is since you are discussing, both of you are discussing the agreement, this assignment agreement, so how should the court deal with this question?
By not dealing with it.
At this point of time, or forever?
At all, forever. This is the Act provides a statutory regime, a comprehensive, exhaustive list of the matters which this court ought to consider, and there is no reference to ownership and entitlement in the statutory regime, so therefore it is not a matter which this court respectfully should trouble itself with.
Okay, Mr. Veron, do you want to comment on this?
Yes, indeed. I'm absolutely horrified by what Mr. Burden is now saying. He is suggesting that this court, the Unified Patent Court that 40 years have been necessary to build, has no jurisdiction to decide whether a claimant is the patent owner or not. Is just saying that should be decided by a national court. That should be probably decided under applicable national law, but this court, the Unified Patent Court, has jurisdiction not only about the claims, but about all the defenses which are raised as objections against the claim. So I cannot imagine that the Unified Patent Court says there is a dispute about ownership or entitlement of the patent. I don't care. I proceed simply because the plaintiff declares that he has a patent. That's simply incredible.
Mr. Byrne, you want to answer to this?
I believe that there are many things in this statutory regime which many clever lawyers will consider incredible. This is no more or less incredible than any of the other provisions in this committee-inspired
Okay, this brings us to the particular provision in justice. So we are just assuming that the question of entitlement is governed by national law, and that the court somehow has to deal with it. Then this gets us to this provision of French law that has been cited in the preliminary objections. You mentioned at the outset of your statement in this video conference that that claimant even hasn't filed to be registered as new owner in the French National Register. How should the court deal with this Article L613-9 of French Intellectual Property Code, just assuming it is applicable?
Could I start first by saying that if the court does consider it should be considering the ownership and entitlement issue, then the appropriate national law is the law of the assignment, which is Dutch law, and we will need in due course to consider how this court will receive evidence of Dutch law and how it deals with entitlement. The point that Judge Rapporteur, you have just raised is one about national formalities, and it is the claimant's submission that under this new statutory regime, that by proudly including its portfolio of patents in this new regime, that one of the benefits the patent owners receive are that they are no longer required to attend to matters of national formality. Indeed, those national formalities are only appropriate and necessary for those patent owners who, for whatever reason, have decided to opt out of this wonderful, brave new world of the UPC and have chosen to treat their patents as national patents. They indeed must comply with those national rules. But
Mr. Byrne, may I interrupt you? But the patent you're relying on is a so-called bundle European patent. It is not a European patent that is giving unitary protection. Does this make a difference?
I think that I accept that it would make a difference compared to those patents which are now pending and in the process of being examined and will one day be granted as truly European unitary patents. The patents which you referred to as a bundle just now, indeed, in my respectful submission, have a special status. They obtain many of the rights and responsibilities of a unitary patent and leave behind many of the rights, requirements and responsibilities such as national enforcement and such as national registration. So that again, this is an area where perhaps there is a gap, but in my submission, the absence of any specific provision requiring national registration means that national registration is not required. This is indeed a relatively minor procedural matter, and if the court considered that the patentee should attend to all these national formalities, these national formalities can be put right, and indeed the claimants would undertake to seek that national registration in the same way that they have sought registration of the change of ownership at the European Patent Office.
Very good, Mr. Byrne. That brings us to the last point, to the question of whether you should be required or the defendant should be provided with translations into 4 languages of all relevant documents. What's your point of view in this regard?
So the article clearly requires a party seeking translation to show the need for such translations, and no such need has been established. The defendants clearly have employees who will work in a number of different languages. They work in the field of media and entertainment, in the application of technology, and Mr. Veron very skillfully avoided answering questions about how the various businesses communicate. I think one can fairly draw the assumption from that avoidance of your question, Judge Rapporteur, that the defendants do indeed communicate in English, as one would expect, and clearly the statement of claim, which was filed and served in English, has caused them no difficulty in preparing and filing their defense, and indeed the only difficulty the defendants have encountered in filing their defense was the French penchant for vacation, which has caused some delay in filing the defense. We also had some very lucid preliminary objections, and as Mr. Veron has demonstrated, he has no difficulty in communicating in English. I have no further submissions on the point of translations or indeed any of the other points, but I'm certainly grateful for any indication as to any points on which you, Judge Rapporteur, would like me to address you further.
This is second part of the video conference, and I like first of all to communicate the decisions of the Judge Rapporteur with regard to the requests of the parties. First, the request of the defendant to hold that the Central Division of the Court of First Instance of the Unified Patent Court is competent to hear this case is admissible as a preliminary objection under Rule 19, paragraph 1b, Rules of Procedure, but not founded. The Central Division is competent to hear the case beforehand with regard to all defendants under Article 33, paragraph 1b, subparagraphs 1 and 3 UPC agreement. With regard to defendant 3, a company having its registered offices located in Switzerland and thus outside the territory of the contracting member states, jurisdiction of the Central Division follows directly from Article 33, paragraph 1b, subparagraph 3, and needs no further explanation. With regard to the other 3 defendants having their registered offices in France, Germany, and Italy, Article 33, paragraph 1b, subparagraph 1 provides that in case of multiple defendants, instead of bringing a multitude of parallel infringement actions before different local or regional divisions, the claimant may bring a one and only infringement action against all defendants before a one and only local or regional division where one of the defendants has its principal place of business, provided the defendants have a commercial relationship and the action relates to the same alleged infringement. The ratio of this provision is clearly to give the claimant an option to avoid parallel litigations against multiple defendants. The court is of the opinion that the same ratio applies when one or more of the multiple defendants have their principal place of business outside the territory of the contracting member states. Also, under these circumstances, the claimant shall be given an option to avoid parallel litigations against multiple defendants. In this case, there is also no justification to limit the choice of the claimant to bring the infringement action only before the local or regional division where one or more of the defendants have their principal place of business and not to the central division. When one of the defendants has its place of principal business outside the territory of the contracting member states, the central division becomes what would have been otherwise the local or regional division, which opens the choice for the claimant to also bring its action against the other defendants before the central division when the defendants have a commercial relationship and the action relates to the same infringement. It follows from these general considerations that under the given circumstances of this case, claimant was entitled to bring its action also against defendant 1, 2 and 4 to the central division. According to the uncontested allegations of the claimant, all defendants have a commercial relationship and the action relates to the same alleged infringement. The request to hold that the case may only be brought before the Italian division is not admissible. The central division has no jurisdiction to decide to which local or regional division a case may only be brought. Next point, the request to hold that claimant's action is inadmissible for lack of standing to bring an action and, in the alternative, to hold the claimant's action as inadmissible as far as the French territory is concerned by reason of the absence of entry of its license, assignment in the French patent register are inadmissible as preliminary objections under Rule 19, paragraph 1 and 4, and also do not give any reason to dismiss the claim summarily under Rule 334H Rules of Procedure. These questions have to be dealt with by the full panel in the oral hearing. The request of defendants for translation of the relevant documents into French, German, Italian and Romansh is admissible under Article 51, paragraph 3 of the agreement, but not founded. Condition of the right to obtain translations of relevant documents in the language of the member states, state of principal place of business or place of business is that the defendant does not have proper knowledge of the language of the proceedings. Article 51, paragraph 3c. Defendants allege only in very general terms that English as the language of proceedings under Article 49, paragraph 6 is not sufficiently understood. These allegations are not sufficient to convince the court that the requirements of Article 51, paragraph 3c have been met. Defendant's business is in the field of developing, licensing and providing television broadcasting services. In this field of technology, English is the predominant language of communication. In addition, it is not contested that the 4 companies that are located in 4 different states with 4 different languages cooperate in the development, licensing and marketing of their services in another language than English. They could not explain that this communication is not done in English. So, Mr. Registrar, please, I have a written version of the decision and I also have an electronic version. I will transmit the electronic version to you and then please also transmit the decision to the parties. And please also keep for the minutes that I am going to set new time lines for the parties with regard to reply of statement of defense and the rejoinder. So claimant may submit his reply to the statement of defense, defense to the counterclaim and possibly application to amend the patent not later than May 1st, 2014. And defendants may submit their rejoinder to the reply to the defense and possibly defense to the application to amend the patent not later than 12 May 2014. So this will leave enough time for the court, for the whole panel, in preparation of the oral hearing to read all submissions of the parties. Right. So this concludes this interim conference. Thank you very much, and we will meet again on 22nd May.
Very well. So, Mr. Judge Rapporteur granted leave to appeal, but only on the jurisdiction issues, and the defendants have lodged an appeal on this issue. The appeal is currently pending. We have now about 15 minutes for questions from the audience about the issues that have just been discussed, unless Mr. Judge Rapporteur, you want to comment beforehand.
Yes, and we are also happy for any comments you might have with regard to the style of the proceedings. Are there some differences with regard or in comparison to proceedings you know in France or in other countries? Also, these kind of comments are very much welcome.
A short general comment, not a comment, an information. The video you have seen is a summary, a Reader's Digest of the audience. In fact, the parties and the judge discussed the pending issues during this interim conference during more than 2 hours and a half, which is quite long for a French point of view in terms of duration. And now as we need, by respect to the audience and by respect to the people who are connected with you today, to respect the schedule. It's 1 minute past 5, and we plan to have a coffee break in 14 minutes. So I invite the audience now to ask the question and to start a discussion with Dr. Grabinski. A special request to the purpose of the broadcasting and registering the audience. Could you please stand up, give your name, when the hostess will give you the micro, give your name, your quality, not swear about the truth, but just say who you are, ask the question, and sit down again. Any question? Ladies, miladies? Gentlemen? Both at the same time? No questions?
That's fine.
Ah, thank you. A question. First one. The second will, the others will come. Wait for the micro, Marc Roger, please.
So, thank you. In Germany, to appear before court, we need a power of attorney. In France, we don't. Will it necessary to bring a power to institute our office, to constitute our office before your court?
With regard to lawyers, attorneys at law, the same requirements apply as according to the national law. With regard to Court of Appeal, actually I'm not sure whether there are restrictions that may apply to the national law also would apply to automatically to the new system. I'm not sure about this, but maybe I can pass this on to a lawyer from France. Do you have any idea? Is there a restriction in this regard?
I lodged my appeal first and then checked whether a power was necessary.
But the principle is the same rules with regards to the qualification of the admission of the lawyers. The same rules apply as in the national systems. That's the principle. It is more interesting maybe with regard to patent attorneys, which can also bring a case provided they have the qualification as a European patent attorney, and in addition either have a certificate which the requirements of which still have to be fixed in the next time. This is part of the obligations of the preparatory committee to lay down regulations with regard to this certificate, and or in the alternative, an alternative experience to this certificate. And there are now different views on this, and we will see what the preparatory committee will decide in this regard.
A question?
May I quote?
Yes, please.
May I quote something?
Wait, the micro.
My name is Walter Holzer. I'm the technical judge. As regards the power of attorney, a representative who claims to be representing a party shall be accepted as such, provided, however, the court may order a representative to produce a written authority if his representative powers are challenged.
Yes, well, this is the general rule, as we have it in German courts, and you probably have it in French courts as well, that you don't automatically ask the attorney at law to present his admission, but only if the adversary is questioning his admission, then he has, of course, give evidence about whether he is admitted to the court, yes or no. This is this general provision.
Another question?
Thank you. Stefan Naumann, I'm an attorney in France. I'm a little bit nervous about standing up and asking a question after hearing these very brilliant briefings on issues that I'm actually discovering and know nothing about. But I did note, now that I've read Rule 334, that it provides that the court can exclude issues along the way, which I believe for French practitioners is a great novelty. And I would welcome the comments of the judges or the practitioners who participated in elaborating this case on that issue, because that is a big novelty for us.
Yes, maybe if I can take the opportunity to have a brief comment on this, because it's quite similar to the question that was raised by Mr. Veron with regard to Rule 334H, which provides that the court also may dismiss or the only judge rapporteur during interim conference may dismiss a pleading summarily if it has no prospect of succeeding. You have seen how I've dealt with these questions, and I think it is very natural that the court and the judges rapporteur have to take a very restrictive approach to this. This really is only addressing some absurd kinds of arguments where when you read it, you know it is wrong. These kind of arguments. As long as you can discuss a question, like you can discuss, we are going to deal with this later today, the question of assignment, yes or no, then of course it is not a question to be decided by the judge rapporteur summarily. And I think the same applies with the point you made. So again, a very, very restrictive view. The court will say, okay, this point is not under any circumstances relevant to decide the case, so we leave it out. These kind of situations are addressed with this, which normally, if we have such excellent lawyers as we have in the mock trial, will never happen.
Une autre question? Oui, monsieur, je vous en prie.
My name is Eric Verbraken. I work for Johnson Controls, and me as well. I found this session very instructive, and I learned a lot. But I have still one question to learn even more. I understood that it is sufficient that there is a relation outside the territory of the contracting states in order to bring the case before the central division, although it will be appealed. But for the time being, this is the situation. Is it then sufficient that there is a relationship, however weak it is? Just an example, if I identify in Switzerland only a supplier, and I sue him as well for contributory infringement, is it then sufficient, even if I don't believe it at all, and if it's just a sham argument, that I can bring the case before the central division?
This question didn't have had to be decided in this case because it was out of question that this commercial relationship between the parties existed, and as you know from the facts of this case, the relationship between the four companies was a very close one, commercial one. Where is the threshold in this regard? Later in the practice of the court, probably this will have to be identified in case law. So this particular situation you are raising, there's just one supplier of one little product. If there is no other relationship, maybe this supplier is not only supplying this one product, but he is supplying thousands of other products. Then I would have doubts whether this would be sufficient in this regard.
Other question? Yes. The microphone, please. Miss, in the front.
Yes, Stanislas Rovaya, Hogan Lovells, Paris. Just one question probably for the lawyers here. I would like to know how impacting the setting of the court, and I mean the being filmed and being away from each other in remote locations, has been as to presenting your arguments, and how smooth or unsmooth the whole exchange has been. I think that would be interesting. I've only been to cases where everybody was sitting in the same room so far.
Interesting question.
I mean, we had the good fortune to have extremely good technical facilities, I think in large part helped by your own firm. But it was slightly strange, although I think in some respects maybe the distance between us was a good thing. But I actually found it surprisingly intimate in the sense that I don't really think anything was lost by being in separate locations, but I think that a large part of it will be down to the quality of the technical equipment. So we had no sound delay. Actually, the quality was better than sometimes. We didn't have any shakiness. We were able to hear each other. Occasionally, when people tried to speak at the same time, there was a little bit of speaking over each other and interruption, but it only took 10 or 15 seconds to for courtesy and politeness to be resumed.
I would like to say that it was a lot of effort to bring all that together, and I cannot imagine that in the real life a court would achieve the same result, because just putting the watches of everybody at the same time is very difficult between the continent and the remote islands. And we experience a lot of problem of standard between the various video conference, and frankly speaking, video conference between more than two sides is extremely difficult. And as far as arguing the case and advocacy is concerned, we were, both of us, three of us, we were absolutely willing to succeed and to provide an end product which is acceptable. But what I could imagine is that if there is a lawyer who wants to ruin the video conference, he has just to put his telephone close to the microphone when the other party is speaking, and it will generate interferences, and the judge will not be able to listen to the other party. So personally, I think the experience has shown the limits of the possibilities of video conference. It requires a lot of technical people, probably 15 people have been working to arrange that at least, and you will never find that in a court at the moment. And in addition, the possibility of tricking and cheating are really important.
Each location needed to have technicians coordinating the sounds, the video, all the system. I think that Pierre and his team sent something like 800 or 900 email, something like that.
You are not only from Paris, but also from Marseille.
My mother was born in Marseille.
Probably 200.
200, sorry. C'est l'inflation. So I hope that the registrar, the real one, will have the people to set up this kind of video conference if it's used, in fact, in the future, because all of us, we know that we have some, in all our countries, I mean, when we have the chance to have a written country, with written law country, many provisions of law are never applied. So I don't know if the central court, the central division will have the means and the possibility and the technicians to set up this kind of video conference, and in the same time, it will, as Pierre mentioned, it will depend on the bonne volonté of the people and different location where they are and their capacity to set up this kind of stuff. But it was a big issue, for sure.
Maybe 2 comments from the judge's side. First of all, with regard to timing, I think Maître Véran had an excellent idea. Let's introduce the central division time, so everybody knows when the hearing is going to start. And secondly, well, if for whatever reason a lawyer is not or is trying to obstruct this kind of conference, of course the answer from the side of the court would be, well, come to Paris or come to Munich or come to London or come to wherever, and then we are going to have a hearing old-fashioned style. That's a clear answer to this. So if it's not, of course, if there are technical reasons for this, where it's nobody's fault, then it's a technical problem. But if there's obstruction, then I think the court will find ways to deal with it.
Now it's time for the coffee break. To the attention of the people who are online, we will be back in due time at 45 past 3. 45 past 3, so you may also at your place have a coffee break. Coffee break now.
So what you've seen right now in the video was about preliminary objection. To my mind, this could possibly also have been done only in written form. So the second part of the interim conference dealt with this preparation of the oral hearing. And in this context, a few issues came up. The first issue was again about entitlement of the patent in suit. And I, as the judge rapporteur, invited claimant to file an application in front of the French patent register, because this hopefully would be a solution for the open question how to deal with Article L613-9 of the French Intellectual Property Code. We will see whether claimant has done so, and possibly also whether he can prove it later in the oral hearing. The next point to deal with was a request of the claimant for an order to preserve evidence against the defendant. In the discussion in the interim conference between the parties, it everybody agreed that there was no it was not necessary to preserve evidence with regard to the question infringement, yes or no, because all facts were undisputed insofar. The question was more whether there should be evidence preserved with regard to the calculation of future damages. However, in a later decision, the judge rapporteur decided that this request was not admissible because it was drafted in a very general form. You can find the decision in the bundle that has been distributed to you. Another issue to deal with was how to deal with witnesses that were offered to the court. Both parties offered witnesses to the court. So the claimant wanted to have the court heard a witness called Mr. Couch Potato, which I cite from Mr. Burden's submission, is a very experienced user of the defendant's EPG system who will explain the operation of the defendant's EPG, the attacked system, from a user's perspective, and who will explain in particular the display of information on a TV screen in response to the selection of channels and the additional information which can be displayed on the TV screen in response to user request. Well, we discussed the question, lawyers and the judge rapporteur, whether it is necessary to have Mr. Couch Potato examined as a witness. And everybody agreed that this was not necessary on the background of submissions of both parties. However, since I was only in the position of the judge rapporteur, and at this point of time I did not know about whether it might become necessary to hear this witness, I invited the party that they can bring the witness to the hearing if they wish so, and so that there would be a possibility for the court to hear if it might be necessary. So I do not know whether Mr. Burden will bring his witness with him to the hearing and whether it's going to be necessary to hear the witness. But the court at this point of time didn't think it was necessary. On the other side, Mr. Véran, as defendant's representative, also invited the court to hear a witness, this time with regard to his counterclaim for the revocation of the patent in suit. And again, I cite from a submission of this time of Mr. Véran. He wanted to hear a Mr. Peter Hallenbeck to be heard as a witness, and he explains he is a US citizen. He can be heard in the language of the proceedings, namely English. Surprise, surprise, after he very much insisted that he wanted to make his submissions in French. Anyway, the defendants therefore requested that the judge rapporteur, or they request in the first submission that the judge rapporteur accede that the witness is going to be heard. Again, this question was discussed between the parties and the judge rapporteur, and again the judge rapporteur took the view that it was not necessary to hear this witness because also the evidence with regard to the counterclaim for revocation was not contested. In particular, there were two screenshots from Wikipedia, but it was not contested by the defendant of the counterclaim for revocation that these screenshots were already available to the public before priority of the patent in suit. So in both cases, the court did not order these witnesses to be heard, but they can be present in the hearing. And a last point that was raised, because this is another purpose for the interim conference, to find out whether the settlement can be reached. Judge very friendly invited the party to give their opinion on this point, but parties very friendly answered essentially, no, we are not interested in a settlement at this point of time. So this was left this question again without any result so far. So these were the case management issues that were raised and dealt with in the second part of the interim conference. So this is the point of time. If you have more questions or comments with regards to the interim conference, where you may ask questions or make comments.
Any question? Would you like to add some point, or Mr. Gawinski, or for you the time is over to go forward?
Yes, I think so.
Okay, if there is no question or comment in the audience, I suggest to gain some time, which is good for the afternoon and especially for the panel, because if we gain some time now, it will give them more time to render the decision, and I know that they are worried about. So may I invite Mr. Girardet and Mr. Holzer to join, and I will leave the place for the panel.
So thanks. First of all, I have to apologize for my very bad English and excuse to the audience. But however, before starting the hearing, I would like to say a few words about the oral procedure we are going to carry out. If you refer to the rules of procedure, you will notice that only 9 rules are devoted to the oral procedures and less to describe the oral hearing. It seems to me that the provision, Article 112 to 115, are not very precise in order to allow the presiding judge to organize in a very effective way the hearing. According to Rule 111, he or she has all authority to ensure fair, orderly, and efficient oral procedure, and to ensure that the action is ready for decision on the merits at the end of the oral proceeding. The aim is also to act without delay, as for the interim procedure before. According to Rule 113, the presiding judge shall endeavor to complete the oral hearing within 1 day. He or she may set time limits for parties or submission in advance, and even during the hearing, after having consulted the panel, he can limit a party oral submission if the panel is sufficiently informed. The oral hearing may start by a preliminary introduction to the action provided by the presiding judge or the panel. In our case, it would be useless, since you are completely aware, after having heard the bright presentation of Mr. Grabinski, of the lawyers, of the registrar. So I propose to start now. I remind the representatives of the party that they agreed to limit their oral submission to 20 minutes each. And I remind also that the claimant asks the court to give its decision immediately after the end of the oral hearing, as Rule 118 allows the court to do in exceptional case. I'm not sure that we have an exceptional case, but we will do as if it is. And we try to reach an agreement within 20 minutes. So, The issues at stake, the matters in dispute, are, if I can summarize. First, should the court stay of proceeding pending the decision of the Court of Appeal on the jurisdiction of the Central Division? Second, as the claimant established its entitlement to sue on the basis of the patent, and namely, does he establish the assignment of the patent has effectively been registered at the French Patent Office? Third, about the counterclaim for revocation of Claim 1 and Claim 2. Does the patent relate to a presentation of information? Is the invention as granted or as amended in the request of the claimant novel over the unique patent application? Does the invention involve an inventive step with regard to the unique patent application and Peter Allenbeck article? Finally, does the defendant's system provided through their set-top boxes infringe the patent? So, Mr. Burdon, are you ready? I will give you the floor.
Thank you, Mr. President. Judges of the panel, I see that Mr. Registrar and his deputy are also present, so I welcome and honor them as well. My new learned friend, it's Mr. Veron and Ms. Amandine Mathieu. It's a great pleasure to be here at the first hearing of the Unified Patent Court. It's a truly auspicious occasion, and it gives me and my firm great pleasure to represent the claimants in this action. I am also very glad and somewhat relieved that the language of the proceedings follows the language of the patent and is in English, with which I have some passing familiarity. But I am also very aware that English, unlike some of the other great languages of Europe, is a somewhat imprecise language, so that if on any occasion my description or language is not clear, I would welcome the intervention of the judges. And so, for example, when I refer to Mr. Veron as my new learned friend, I do not wish to suggest in any way that his learning is only recent, but rather that he is an acquaintance who I have met only recently. He is new learned friend in that context temporarily. I make no comment about his degree of learning. But then again, we are all newly learned in this brave new world of the unitary patent and the Unified Patent Court. So with that, I will get down to issues of substance. There are, as you all know, and as of the judges have outlined, several issues with which to deal, and I have limited time, so I would also appreciate any intervention and indication from the panel of judges as to how you wish to proceed, and certainly any direction you can give by any questions you can offer me. I propose to start by talking a little about the patent in dispute. And this is patent 1003442. That patent designated various contracting member states: Austria, Belgium, Germany, Denmark, Spain, France, UK, Greece, Italy, Lithuania, Luxembourg, Netherlands, Sweden, and Switzerland. Now, Switzerland, as I was educated during the course of the interim hearing, is not a party to the agreement, of course. And Italy and Spain on my recent researchers have not signed the UPC agreement, but all those other countries which are designated on the patent have indeed signed the agreement and have ratified it. And I wish to clarify and reiterate that the scope of the claim and the scope of the remedies sought in these proceedings applies to all those contracting states in which the European patent has been validated nationally and which are members of the Unified Patent Agreement. This claim is not limited to France, Germany, and Italy, as seems to have been suggested. The claimant obtained ownership of this patent pursuant to an assignment and has duly registered that transfer of ownership at the European Patent Office. And recently has now successfully registered that transfer of ownership in all those countries which are the subject of these proceedings. There seems to be some confusion in relation to the registration in France, but following the case management conference, the claimants took the respectful suggestion of the Judge Rapporteur and registered the assignment or the transfer of ownership at the French Patent Office and all other relevant contracting member states, and indeed testified to that fact in paragraph 2 of the reply and defence to counterclaim, which was filed and served on the 1st of May. I don't believe that with that registration there is any issue about the entitlement of the claimant to bring these proceedings. But perhaps I might be given a limited right to answer if the defendant's representative raises any new and surprising issue on this point during the course of his submissions. And if that is a satisfactory way to proceed, I perhaps also ought to deal at the outset with the question of a stay. Now, it was perhaps not apparent from the earlier production, which seemed to suggest a very efficient, cooperative, and engaging participation in these proceedings by both the claimant and the defendants, what is indeed the true story. Unfortunately, the defendants have tried every possible procedural game or tactic available to them to delay these proceedings. We heard the various objections that were made, the lack of provision of the preliminary objections in the English language, in the language of the proceedings. We then had late service of pleadings, where unfortunately the cat of the secretary to Mr. Veron ate his manuscript notes, delaying their typing into a proceeding. We then had a delay in the reply and the rejoinder and the reply to the defense to counterclaim with no justification or excuse whatsoever. Now, clearly, in these early days of the Unified Patent Court, the defendant and their representatives seemed to be taking any recourse to delay the moment of truth when they are found to be infringing this valid patent and should duly be injuncted and paid compensation and various other remedies. There is no reason to delay this trial. We are here, we are ready. The parties and the court at considerable expense has arranged this hearing, and we should proceed. So again, subject to any new and surprising points that the defendant's representative might make, I will make no further submissions on the question of the stay of these proceedings pending the appeal on the jurisdictional issue. I would then like to turn to the patent itself. The patent has a priority date of September 1994. The title is a method and apparatus for accessing information about television programs. There is a method claim and an apparatus claim. It is clear that this invention is about a system for managing a considerable amount of information and enabling that information to be partitioned and selectively supplied and viewed by a user. I would caution against the shorthand abbreviation of describing the invention as merely an television electronic program guide, or TV-EPG. This invention is to a system and process that has various detailed technical requirements. And the patent recognizes the prior art. In paragraph 2, we see that when using a television set as a display for a television schedule system, the size and resolution of the display limit the amount of text that can be displayed with the grid, and that improved techniques are required for conveying the most amount of information to the user in an easily understood manner within the limitations of the television display, and that when a large number of channels are available for viewing, there's also a need to order the display of information most conveniently for the user. The patent then goes on to summarize the invention in paragraph 3, that it's an object of this invention to provide a television schedule system and process with a user interface that is configured to compensate for the nature of the television schedule information. And further, that it is another object of the invention to provide such a user interface in which supplemental schedule information is presented in overlays that obscure a minimum amount of useful other information. What this invention enables is for a significant amount of broadcast information about television programs to be supplied and stored in an encoder device and then accessed by a user in a way which partitions that information to allow it to be viewed, taking into account the restrictions of the television and television screen. If I could perhaps turn to the claim, which I hopefully have on screen here. I think there is no disagreement between us about the division of the claims in this way into A, B, and C. There perhaps might be some disagreement, at least on Mr. Veron's part, about the meaning of some of these words. But if I can take the judges through this, we have, and I'm using the apparatus claim, claim 2. The claim 1 is to a method claim. It is, to all intents and purposes, the same or as the apparatus claim, and there is no distinction between the two that matters. But here we have part A, means for storing in an electronic memory of a schedule controller operably connected with a monitor screen of television program listings, including title, time, and channel. Part B, we have means for displaying on the monitor screen an overlay, providing from the stored listings some selected information, limited information. Now, that information, or that overlay, is generated simultaneously when a channel is chosen on the TV screen. So when a television channel is chosen, a small banner appears normally at the foot of the screen, which shows the title and of the program which is currently being broadcast and the channel on which that program is being broadcast. And that happens simultaneously, or perhaps you might consider automatically. Part C is a second type of overlay. Here we have means for displaying, importantly, responsive to a user input, a further overlay containing further information on the selected program, so that when a user is viewing a television program and wishes to know some more detailed information about that program, they can use a button, normally on their remote control device, which produces a second or further overlay which displays a different type of information, more detailed information about that selected program. Now, so far, so clear, but I perhaps should highlight what I believe is one of the central issues, which is, I believe it to be the defendant's case that there is some form of relationship between these two overlays, in that the second overlay, which is generated as a result of user input or user selection, is itself superimposed upon the first overlay, which is generated automatically or simultaneously with the selection of a television program. Now, while I accept that the invention could potentially work in that way, that would be one embodiment which is within the scope of the claim, but the claim is not limited to that embodiment.
If I may intervene at this point of time, I'd like to draw your attention to figure 3 of the patent in suit.
Yes.
So this is showing a first overlay, which is the grid, the program grid.
Yes.
And it is showing a second overlay, which is, at least according to my understanding, is superimposed to the first overlay.
Yes.
So what is your, how do you deal with this figure 3? And it is, I think, similarly explained in the description of the patent in suit. So what is your point of view with regard to this figure 3 and the corresponding text in the description?
I see the cheerleaders are also in town. The question is, with respect, a very good one, but it highlights exactly the point I was making, that the television grid shown in figure 3 of the patent, and I apologize that I'm not able to display that on the screen, but that, if we look back to the description of the patent, is one of the drawings and is under the title Brief Description of the Drawings, and indeed that is one embodiment.
If I can help out, for example, if you look to number 17 in column 3 of the patent in suit, last sentence, I read from this sentence: program notes are overlaid on the list. So the list is the first overlay, and program notes are overlaid on the list, in brackets, overlay, in the same manner as shown in figure 3 of the grid 24.
Yes. That is clear that in describing figures 3 and 4, the second overlay, which is user generated, is superimposed on the overlay which is automatically generated, but that there is nothing in the claim and there is nothing in the body of the patent which limits the scope of the invention to that particular embodiment.
Perhaps a last question in this context, draw your attention also to number 4, column 1 of the Patent Institute, which is a general summary of the invention. And there, about number 4, it is said it is another object of the invention. You already cited this, I think.
Yes.
Another object of the invention to provide such a user interface in which supplemental schedule information is presented in overlays that obscure a minimum amount of useful other information.
Yes.
So what does it say with regard to, or what can, what would the person skilled in the art concludes from this sentence of the description?
Again, in my submission, that sentence and that passage is entirely consistent with the construction which I, or the meaning of that I've proposed of the claim, and that the obscuring of a minimum amount of useful other information, maybe with respect, Judge Rapporteur, you're considering the figure, but that other information could be the television program which is being broadcast at the time, rather than the information in the grid of the electronic program guide.
So it would be possible to have one overlay and a little overlay beneath, which is not necessarily superimposing the first one.
So I have shown this slide to the defendant's representatives, and I anticipated this question and if I can move forward. So this is a photograph which I took myself of my own television. I was not able to rouse Mr. Couch Potato to assist me at the time, but here we have a first overlay which is generated simultaneously or automatically upon the selection of the channel, in this case ITV3, and then a second overlay which shows more detailed information about that very same program, which is generated in response to pressing the information button on the remote control device.
I have a question in this regard. I mean, being a patent attorney, I'm always surprised when I read a new patent claim. But what you explained to us now as regards the overlay, how does this fit, or how is the language, the broad language of the claim, supported by the description? That means the claim, for example, mentions a plurality of program listings displaying an overlay. So this would not be a plurality of program listings, what you showed us just now.
Beg your pardon, could you just remind me where you found that reference?
The reference?
Yes.
This is in the claim.
In the claims. The plurality. Shall I go back to the
program listings displaying on the monitor screen an overlay? So the question is, well, this is, yes, this perhaps.
So the plurality of television program listings describes the information which is stored in the electronic memory of the schedule controller. It is not a requirement of the overlay, either the first overlay in category B or the second overlay in category C.
Okay, fine.
And just in case I wasn't clear, the embodiment described with particularity in the drawings is indeed within the scope of the claim, but it is a particular embodiment, and the claim is not limited to that particular embodiment, as is apparent from the plain language of the claim. and certainly the European Patent Office took no point about support, and indeed that is not a ground which is open to the defendants as a ground of revocation in these proceedings. I should also add that there is also no claim that, or no allegation in the counterclaim for revocation that the patent does not contain clear instructions to enable the invention to be performed by a person skilled in the art. The objections are limited to classic novelty and inventive step, and the perhaps less classic exclusion of patentability based on presentations of information. So with that in mind, I will deal just briefly with the question of infringement. I think, as was noted during the introduction to the case, there is no dispute about the identity of the defendants, the acts of the defendants, the relationship between those defendants. They were clearly set out in paragraphs 14 to 20 and 21 to 23 of the statement of claim.
If I may help you to cut it a little bit short, could you please, when you discuss infringement, just for a minute, assume that the position of your adversary, Mr. Veron, is right?
Yes.
So if you argue from your point of view with regard to interpretation, I think it is a rather easy question to answer. But just for a minute, assume that Mr. Veron's interpretation is the right one.
So I have placed on screen what is agreed between the parties to be the outward manifestation of the defendant's system. As I understand the defendant's case of non-infringement, they believe that the panel, which has the more detailed information about the film The Shadow, is not superimposed upon the background of the television guide. I think the consequence of that is that if it were technically possible to remove that information, that panel, there would be a blank screen where that panel currently exists. This is not supported by any evidence in the case. It would have been very straightforward and simple for Mr. Veron to remove that panel and take another screenshot of the program guide without that panel, but we have no such evidence. We saw a rather forlorn attempt in the tail end of the pleadings to suggest that somehow the other parts of the program guide were truncated and shortened to make space for that panel. But there is no evidence of that, despite the point being fairly put right from the outset in the statement of claim. Judge, are you happy I proceed with validity, particularly bearing in mind the time? The defendant cites two pieces of prior art, one Hennig, one which I'll call Hennig, and one which I'll call Hallenbach. Hennig, if I can take it briefly, is a patent application. It was filed, or it was rather published in 1991. There's no dispute that it's available prior art within state of the art. This patent, in essence, is about deriving information about the timing of programs from teletext signals. Now, many of those in the gallery to this court may not have had the misfortune to experience teletext, but it is a rather primitive form of information which was available several decades ago. and nothing like the type of information which is available today. But one of the important points is that this provided a means in which to calculate the remaining time of a program and display that program by interfering or intervening and taking the signals that were generated through the teletext system. There is no clear disclosure in Hennig, and being brief about this, of the type of electronic memory which is in Part A of the claim. There is no suggestion of the display, automatic or simultaneous display of that information upon selection of a channel. It's not clear how and in what circumstances that information is provided, and indeed there is certainly no information which is displayed which is as a result of user input. So in my respectful submission, it doesn't get close to the invention, and there is certainly no suggestion of anything of the method or apparatus which is claimed in the patent with its various features. And indeed, maybe the defendant was unaware of this, but the second piece of prior art that the defendant relies upon actually distinguishes Hennig itself, and if the judges would be kind enough to look at page 311, or the page numbered 311 in the Hallenbach publication, about halfway through the first full paragraph in the left-hand column, we see a sentence that says, "This local storage makes the system very different from a teletext system and allows for many original features." So we see here a contemporaneous account within the prior art distinguishing the Hennig application. Shall I proceed?
If you can conclude yet.
Yes. In general, we see from Hallenbach that there is a considerable amount of explanation of the technical background there. We see the development of the superguide system as he describes it in two parts. But this is, in essence, a way of presenting a television program guide which then enables the user to select a channel from the program guide. The claimed invention is the reverse of that. With the claimed invention, the program information is generated and displayed automatically upon selection of the television channel, not the other way around. And indeed, when we see the screenshots of the Hallenbach superguide device, we see quite a primitive, this is the superguide 1, we see a primitive setting out of the channels, and then what is described as as superguide 2, where the technical achievement that was introduced was essentially about the addition of color and a different pixelated display. Again, if we come back to the claim itself, we don't see anything in Hallenbach which provides the two different types of overlay that are in B and C. Fine.
Thank you very much, Mr. Bauer.
Do you like me to deal very briefly with the presentation of information point, which is a point of substance?
I'm sorry, because we have...
Fine, but you have my you have my submissions in the reply, and you can see from
Thank you very much, Mr.
prior art.
Roberto. So, I will give the floor to Mr. Vermont, to Mr. Mettier, Mrs. Mettier.
Thank you.
Thank you. We are listening to you.
Dear President, dear member of this court, it's really a great honor to plead this case before you and before this respectful audience. Before leaving the floor to Pierre Véron with respect to the invalidity and non-infringement issues in relation to this patent, I will address briefly some procedural but not less important issues. First, as main request, we request that your court stay the present proceedings, waiting for the decision of the Court of Appeal on the very important question of the jurisdiction of the Central Division of the Court. As you know, we respectfully challenged this jurisdiction during the interim conference. So Judge Rapporteur dismissed our claim, but he authorized us to lodge an appeal on this issue. As he said, this issue is of fundamental importance. So we think it is really important for this court to stay the proceeding pending this decision of the Court of Appeal, not only for this case, but also for any future case which will have the same configuration of the parties.
May I ask a question to you? Would you also like the court to stay proceedings if otherwise the court would dismiss the claim?
Well, next point. Should the court decide not to stay the proceedings,
okay,
the defendant asks that the court declares the claim and action inadmissible, or at least as far as the acts performed on the French territory are concerned. As you know, this defense has already been raised in front of the Judge Rapporteur, but was only held inadmissible as preliminary objections. So that's why we think this defense deserve to be heard in full audience by your court. So we consider the claimant's action should be held inadmissible as he does not prove being the holder of the patent at issue. As you will notice in the assignment agreement, only the patent listed in Annex 1, which all share the same priority US patent application, have been assigned to the claimant. But the European patent at issue is not listed in this annex. That's why we therefore request that this action be held inadmissible, because it is really a question: has Telecast the standing to bring an action before your court? And your court cannot simply take the claimant's word for it. So that's why we request this action to be held inadmissible. In the alternative, and we are happy to hear that the claimant complies with the French requirements as to the registration of the assignment agreement in the French patent register. But we have seen no justification of this registration, and as far as French law is concerned, this registration is only enforceable as soon as it is published in the French Patent Office bulletin. And so far we have seen nothing in this respect. And should the court decide that this registration is complied with, we consider that only the act performed after the registration could be the subject matter of this action. There is no retroactive effect of the registration as far as French law is concerned. So, as far as these preliminary but very important issues are concerned, I'm finished, and I leave the floor to Pierre Véron with respect to invalidity and non-infringement.
Mr. President, Mr. Judges, before dealing with the issue of patentability and infringement, I have something very important to disclose to the court, a new information which has just arrived a few minutes ago. You certainly have noticed that the address of the claimant has changed during the proceedings. You have carefully read the documents, and you have seen that in the statement of claim, the claimant was domiciled in Schouwburgstraat at The Hague. It's at page 3 of the statement of claim. And at a later stage, the claimant changed its domicile to Pompstationsweg in Den Haag. Everybody knows Pompstationsweg in Den Haag. You know it for sure. This is the Schwenningen jail where the most criminal people in the Netherlands are imprisoned, and where the international criminals are also put in jail. This is the very jail where the United Nations put Mr. Gbagbo and other people like. And the claimant has its domicile at this address, and every notification is duly served at this address. This is the only case where a patent troll has been put in jail, and he does not hesitate to bring a further case before your court.
But Mr. Varon, don't you think that everybody has to be treated equally before the court?
Yes, of course, but the court should be informed of who is the claimant, a patent troll currently in jail for trying to extort funds from people, honest businesses like my clients. This should be taken in consideration when assessing the validity of the patent. So, this being said, let's turn to the counterclaim for revocation of the claims of the patent at issue. My learned and long-time friend, Mr. Burden, has been clever enough not to mention that he has been obliged to file amendments to its claims, because he was very well conscious that these amendments had absolutely no ground and cannot improve his desperate case. But he did file amendments, and I will have to convince your court that these amendments are not admissible. But my main defense is to say that the invention is not patentable because it's a mere presentation of information. If it proves to be patentable, which would be surprising, it lacks novelty, and in any case, it lacks inventiveness. First of all, I request the court to say that the claim one as granted is that claim that you can read. It has been explained by Mr. Burden. I will not go further. It, in fact, is duplicated in claim 2 for an apparatus, but what it aims at covering is a combination of 3 means for storing information in an electronic memory, means for displaying an overlay on the monitor, and thirdly, displaying, responsive to a user input, a further overlay containing further information. So this is the claim, which is basically the same be it for a process or for an apparatus, and the claimant accepted that we can deal both claims in the same discussion. The first point I have to make is about the amendments which have been filed. The first amendment, first set, is just to replace further by supplemental. I've carefully checked the English dictionaries and even the Australian dictionaries, and have not been able to locate any difference between further and supplemental. So I think it's just to waste the time of the court to file such an amendment. The second amendment is much more long, and but in fact does not bring anything more. It's just a repetition, and it doesn't bring anything, and this is why Mr. Burden did not explain that in much detail. My legal position about this amendment is that they are inadmissible because there is a specific provision in the rules of procedure that when you file an amendment, you cannot just say, I put the amendment on the table of the court. You must explain why you put the amendment on the table, and you must also take the initiative to explain that your amendment satisfies the requirement of Articles 484 and 123 of EPC, and why the proposed amended claims are valid and infringe. And you will not find any attempt from the claimant to justify.
Would not supplement mean a supplement of the contents of the first information you put on the screen that is supplemented by further information? So further and supplemented is not the same. And does the patent speak about supplementing the first information that is put on the screen by an information that relates to the contents of the first information?
Well, if I may join, could you give your interpretation of further? What does further mean in the patent claim as granted?
Supplemental. Further is an exact synonym of supplemental.
Well, I'm referring now to what we already discussed with your adversary, superimpose. The first overlay superimpose, the second one superimpose on the first one.
This is a very good question that I would like to broach at a later stage of my explanation. Okay. But if you feel it appropriate, I can really give you more information in that respect. It is clear from the patent, and I will jump to my last slide, if the man in the cabin is able to jump as quickly as you are jumping.
Because I have the feeling that this is a very important question.
Yes, of course it is. Not the very last, before, thank you. What I explain is that there is no infringement because the proper construction of the patent is that overlay means superposition, and that figure 3, which you very rightly and very wisely mentioned as being extremely important in the case, this figure 3 does show a square rectangular box superimposing on part of the screen. So the very meaning is that a further overlay is something which superimposes over the existing screen. Figure 2 shows what is on the screen at the first stage, and figure 3 shows what is on the screen in response to an order from Mr. Coach Potato on the onset.
But Mr. Burden is telling us that this is just an example. Well, he is trying to where do we find a certain reference in the claim. The claim only is saying further. He's not saying superimpose.
Yes, but further is something vague and imprecise, and you have to give an interpretation. Right. And to give an interpretation, you have to take into consideration the whole content of the patent notably the drawings and the examples. And obviously, the only example which is given is the example of a superimposition of an image which is hiding the background.
That's right.
May I turn back to my second slide? No, I think I have covered your point.
Yes.
Okay. So I see no difference, and I wanted to mention that the amended claim are not admissible. My further point is that there is no patentability because the patent covers only a presentation of information. Mr. Burden has been clever enough to be long enough not to have time to cover this objection because he has simply nothing to reply on in this respect. It is clear that this patent is just a presentation of information. There is no technical means disclosed to operate and to have the information overlaid and further overlaid. There is absolutely no explanation. The patent tries to cover the very fact of presenting a program guide over a current television screen and to further cover part of this program when in response to a specific instruction on the handset of the user. So it's just a way of showing and presenting information in a specific context, and everybody knows that when you have a lot of information to disclose and to display, the better solution is to cut it into small pieces and to put the pieces consecutively in sequence, so that exactly what the patent does. The program information is too long to be on one screen, so it is cut in slice, and the further information is called. This is something which has been done since the paper has been invented. When it is too long to be on a papyrus, then you cut in a sheet of paper, and the patent has nothing more than done what the inventors of papers have done in some time ago. The patent is, in any event, not novel in view of the patent of ENIG, which also relates to an electronic program guide displaying information on programs. This is clear in the drawings of this patent. The information is stored in a decoder and retrieved when necessary. It's not a continuous flow of information coming from a server. It's clear from the patent that there is a microcomputer in the television or in the set-top box, which stores the information. This information is then displayed in an overlay, and the patent gives two examples. That information is in a square, in a rectangular box, 540 and 540-, which superposes on the original picture. So the teaching of ENIG is already to display the information when you select a program, and it is further explained in ENIG that the display indicating the remaining duration has to be updated during the time the microcomputer waits the next appearance of pages, and if desired, the title of the program can also be displayed. So it implies that if you want to have more information, you can just, if desired, display the title of the program.
But Maître Véron, it's still the same banner. It's not the second banner that is dealing with the next program.
that's your reading, and it.
That's what you see in these pictures.
No, but what you see, you have not only to see in the picture that it is not in the patent that the information has to be on a specific further information. It can be superimposed in the same box as is currently shown.
But there is no. But were you? Is a proof for this in the application? This is.
What I read is the display indicating the remaining duration has to be updated during the time the microcomputer waits the next appearance, and if desired, the title of the program can also be displayed. That means that you can display the title of the program if needed. But maybe this is not fully disclosed, but then the question turns about inventive step. If it is not novel, it's a matter of inventive step. And this leads me to the discussion about inventive step. We have discussed inventive step in view of Hallenbeck, but as the judge rapporteur decided that he didn't want to listen to Mr. Coach Potato nor to Mr. Hallenbeck, we are no longer discussing Mr. Hallenbeck, and we will mainly discuss inventive step in view of ENIG. If you look at ENIG, again, you will see the three features of the claim: storing information, displaying on the monitor screen an overlay, and displaying responsive to a user input a further overlay. Let's assume, as you are mentioning, Mr. Judge Rapporteur, that we have not the typical characteristic of the display of a further overlay upon as a response to a user information. Then the only difference would be as shown in this diagram, meaning that you are in the left-hand side picture. You can see the program. When you arrive to the program, you can see the picture in the middle where there is basic information, and the next step would be, as a result of a press on the button of the handset, to add further information. So the question is it inventive in this concept? When it is known to make automatically appear the basic information about the program, is it inventive to decide that on the touch of the button you will have further information? You will sort of turn the pages of the program guide. I say in view of the knowledge of the man skilled in the art of the time of the patent, it was something very simple that does not show any inventive step. And if we are in the extreme alternative to discuss infringement, if we are to discuss infringement, as the court mentioned and as already seen, the patent implies that the further overlay is a further layer which superimposes the basic information. And in our set-top boxes, which are marketed, the situation is different, meaning that when you are at the first step, when you change the program and you watch a new program, the list of the program takes the full page, occupies the full page. And if you want to have more information about a specific program, in our example, the Shadow, fascinating program, then you press on your handset and it appears in the bottom of the page a new rectangle, and to give room to this new rectangle, the upper rectangle compresses. So there is no superposition. The shadow does not hide anything, because the further part of the box is simply reduced and room is made for the further information, which is something very different from what is in the patent, because the patent, again, and as very rightly mentioned by the judge rapporteur, shows that the fascinating information that Dorothy brings Sophia's sister over from Sicily as a birthday surprise comes up as a pop-up and hides the information Walt Disney presents Jane Wallace, which can be seen on the other page. So the construction, the proper construction of the patent, the purposive construction, as an international court would say, of the patent, of the overlay, is that there should be a further overlay superimposing and hiding the basic overlay for the patent to be infringed, which is not the situation in our device, where there is no further overlay, but simply a part of the information is stretched to give more room to the additional information.
From a technical point of view, where in the claim 1 or claim 2, do you find the superimposing feature?
The claim is obscure and should be interpreted. And it can be interpreted only in view of the drawings, because the patentee has not been fair. Keep in mind that he is in jail now.
We are very short in time indeed, and I will ask to conclude if you wish.
Okay, I'm done. It's okay, and I would like to thank you, the court, for.
We thank you both.
One very short question to Mr. Burden. Do you have any proof for that you applied that the French part of the European patent is registered in the French registry? Any proof that you can submit right now?
Right now. Proceedings are closed. I object.
Indeed, the evidence is already in the proceedings in paragraph 2 of the reply, which is, of course, has sworn under oath as truthful.
It is just an assertion. There is no document which has been exhibited.
Okay.
Thank you very much, both.
It is a little difficult to find the printout of this registration.
15 or 20 minutes, which is a big challenge for us and for you too, because you will do the same exercise. So we come back by 15 minutes. So the court is signed.
Hello. The court is retiring to, is going to render the decision. But as mentioned already, you're going to work a little bit. I presume that you received this sheet of paper, verdict sheet. You have? Okay. This is the list of the question the court needs to respond. And during the délibéré, during the time that the court will try to render a decision, we will do the same exercise on our own. And step by step, we will go through this verdict sheet. And I will invite you to vote like this, yes or no. And we will see My deputy registrar will note the majority, and we will see at the end of the afternoon or before the end of the afternoon if the audience is in accordance with the decision to be rendered by the Central Division of Paris. So the first issue is the following: stay the proceedings pending the decision of the Court of Appeal on the appeal lodged by Blue Cable and TV Grid on the issue of the jurisdiction of the Central Division of the Court.
So please raise your hand if you're, if you're in favor of a stay.
So who is in favor of a decision of stay except my friend Pierre Véron and curiously my friend Sabine Ager? Who is in favor of a decision of stay? 1, 2. You think it's a question of majority? I don't think so. So
if we have a majority, we will just leave the room for now.
Okay.
I think
by chance we can say no stay.
The second issue to be decided is the admissibility of the claimant action with regard to the fact that the patent in suit would not be listed in the appendix of the alleged assignment. So please raise your hand if you think that the action is inadmissible in that respect. Okay, so
a strong majority for yes.
The third issue also pertains to the inadmissibility, but as far as the French territory is concerned this time only, due to the lack of recording of the assignment in the French patent register. So please raise your hand if you think that the action is inadmissible in that respect.
Strong majority too.
The fourth issue to be decided is the request of the defendants to dismiss, request of the defendant to dismiss the request for amending claims 1 and 2 made by the claimants due to non-observance of the provisions of Rule 30 of the Rules of Procedure. So please raise your hand if you believe that the amendments should be dismissed.
I think that we have no majority.
So amendments of the claims are agreed.
Yeah.
The next issue to be decided is the validity of the patent suit with regard to patentability of presentation of information. Please raise your hand if you believe that the patent is valid in that respect, is patentable, the invention is patentable in that respect. Patentable.
Patentable.
It's not a clear case. What do you think? I think we have a very short majority, but I'm not completely sure about that.
Short majority, we will say.
Then the next issue is the validity of the patent with regard to novelty. So please raise your hand if you believe that the patent is novel.
Is the patent novel?
The patent is novel.
Majority.
And now the next issue is the validity of the patent with regard to inventive step. So please raise your hand if you believe that the patent has inventive step. I don't think we have a majority, so the patent lacks inventive step.
We have no majority.
So, even though, as decided by the members of the panel, we will decide on infringement, even though the patent has just been declared invalid. So
yes, it's very. I remember you that if in France a decision may stop from the moment that the patent is declared invalid, in many jurisdictions around France, the judge will go forward, even if it considers that there is an admissibility issue or anything which would invite a French judge to stop the job. But in Germany, for example, or in the UK, if even if in Germany, in the UK, if a patent is declared invalid, the judge will consider the infringement. The reason being that the Court of Appeal must be in situation or in position to deal with the first instance court decision on all the aspects which were on the table. So it's a very specific rule which may surprise some French practitioner, but just to remind you this difference. And we may presume that this approach will be shared by the Central Division in the future. This is why the question is still pending.
So please raise your hand if you believe that claims 1 and 2 of the patent are infringed. I don't think we have a majority.
No.
No.
No majority.
The patent is not infringed.
So we can stop there. No?
Assuming that the patent would have been infringed,
yes.
We can now decide on the claimant's injunction, request for an injunction to restrain the defendants and each of them from infringing the patent, whether by making, offering, placing on the market, using, importing, or storing a product which is within the scope of Claim 2 of the patent, by using a process which is within the scope of Claim 1 of the patent, or in any other way, any compliance with the aforesaid injunction which shall be subject to a recurring penalty payment payable to the court. So please raise your hand if you would like to grant such an injunction.
No majority.
Yeah, assuming that the patent is infringed.
Assuming that the patent is infringed, of course. No majority. Apparently no no majority.
So the patent is infringed, but defendants can pursue an infringing the patent.
This is very logical. Sorry?
Yeah.
Absolutely. Just damages. But it's patent troll, so.
The claimant made a request for an order for the delivery up or destruction upon oath of any product which infringes the patent, whether by recalling the products from the channels of commerce, depriving the product of its infringing property, removing the products from the channels of commerce, and or destroying the products and or of the materials and implements concerned. So please raise your hand if you want to grant such an injunction, such an order. Okay, no. The order is not granted. And then damages suffered by the claimant as a result of the acts of infringement. We cannot decide on the amount of damages by raising our hands, but we assume that the audience would want to grant damages. Please raise your hand if you...
On the principle, not the amount, of course. Yeah. Yes, we have the majority here.
Can you please raise your hand? I have doubt about the majority.
No, I think it's okay.
Assuming again that infringement was found, the claimant made a request for an order for publication at the defendant's expense of any judgment in which the defendants and each of them are found to have infringed. Please raise your hand if you believe that such an order should be issued. So we don't have a majority. The publication is not order. And the last issue is the legal costs, since the patent was not found infringed. please raise your hand if you believe that defendants should be reimbursed the legal costs.
I hope you will have the majority.
I don't know if we have a clear-cut case here. Okay, reimbursement granted.
Okay. We were supposed to stop at 15 past 5, and it's 13 past 5. So we have 2 minutes. We could think something. No? Somebody wants to think something? No? Or make a prayer for the election? No? Or make a comment? Yes, please. Could we have a microphone for this gentleman? Maybe there is one here, just here, nearby us. Merci, Sabine. It's a comment, I suppose. Not a question, because there is nobody to respond.
It's a very technical question. I think Juge Rapporteur mentioned that the brochure has been handed over to us with a copy of the patent and things, and I was considering whether we received it by email, but personally I haven't. So for us it's difficult to identify and respond to the questions quite knowingly, as we don't know the full merits of the case nor anything. So is there any chance that we'll be provided with the documentation on which you are relying to make this session, which is very interesting indeed?
No problem.
Thank you very much.
There is no problem. It's $200 in cash. No, of course, I think, Sabine, you could respond maybe, because you were dealing with this type of issues more
Yes.
than I did myself.
So, you should have received an email, but just to let you know, there's a website who's been opened for the event, on which the event has been broadcasted live, and you will be able to see it again in replay for 6 months. On this very website, you can download from it. You can download the invitation, the program, as well as the binder of documents that the councils and the judges had. And the address of the website, I'm not sure whether we can we display it? Not sure. So shall I give it, maybe? So it's www.opininews.com/ujube. Very easy. So opnews.com/ujube. OPNews, OPI news, like news, in one word, .com/ujube, as the name of the association. And there's no password, so anybody can access it.
And it's free of charge.
Yes.
Another question or comment? No? Excellent.
Yep.
Yes, please, sir, please.
I don't know if it's a joke or about this jail and these patent trolls and so forth. I didn't know that patent trolls were jailed even in the United States, but it shows very clearly that there are in the fine facts of this whole case issues with respect to inventiveness, which are very tight, and perhaps indeed this is the type of patent that has already been used and put in practice in fact by a number of people without us being able to document it in such a way that we don't have to go through all these arguments about the patent being still valid because not clearly shown in life.
Okay, the judge were supposed to be back at 15 past 5. They were asking 5 minutes of credit. So it will be a great pleasure for me to give some time to a judge. because sometimes we are asking for some time more. And when the judge needs some time more, they don't ask nothing. So for once they ask us if they could have 5 minutes, and of course we are delightful to have responded yes. So we have 2 minutes to stop and to make silence, 2 minutes of silence. My wife will explain to you that it's extraordinary if they are coming back right in time. The court. And then we will have a drink. Non. Oui, bien sûr. Of course.
So, very briefly, because as you know, we are very short in time, and we have no time enough to discuss about all the issues. So we have decided to approach the several questions which is at stake, and we can reserve some of them. And we will share the reply, the feeling we can get after reading the pleadings and after hearings, all hearings. So, on the first question, request stays the proceeding pending the decision of the Court of Appeal on the appeal lodged by the Blue Cable and TV Guard and the issue of the jurisdiction. The first question, it seems to us that this request has to be dismissed as regard to the motivation of the decision given by the judge rapporteur, and I invite you to refer to the motivation of this order. Second question. The court considers that telecast is admissible to sue, as standing to sue as telecast justified to be the holder of the European patent, especially if you refer to the Assignment Act. I haven't got under my eyes at the moment, but if you can refer to the Assignment Act, you will see at the bottom of the first page, thank you very much, that Article 1 interpretation of the Assignment Act, you will discover that patents means the patents and patent application filed under priority of US patent number 555, whose details appear in annex. So even if the patent, our patent, we are discussing about it, is not on the list of that, it has the same priority of this one mentioned in the Article 1. But point 3, the court holds that there is no proof of no proof at all of what Mr. Berdo told us that he has done. There is no proof of registration for the French territory of this patent. So, as in application of Article 639, as I can remember, of the Intellectual Property Code, so the request is inadmissible as regarding the French territory because the assignment has not been entered in the French patent register. For the other question, we give you the speech first about the validity.
I start with the patentability question. The patent has been granted by the European Patent Office, which is a first indication that it is patentable. Now, Mr. Véron has completely ignored the technical features that are listed in the patent, such as an electronic schedule controller, including an electronic memory for storing information, a monitor screen operationally connected with the schedule controller, first signal means for displaying, in a manner known per se, on the monitor screen a first overlay, a second also signal means for displaying responsive to user input, another feature, a further overlay. So in short, briefly, we believe that the patent is patentable. Now, as regards the lack of validity, we believe that the Hennig patent simply does not disclose all of the features of the claims. In particular, it does not disclose feature C of the patent claims 1 and 2 entirely. So the question of validity is decided in that the patent is valid in that respect as regards novelty. Okay? Now on the inventive step.
Yes, inventive step. First of all, before dealing with the inventive step, we should give an interpretation to patent claims 1 and 2. Dealing with the question of a further overlay, meaning the second overlay. Does it mean that necessarily the second overlay has to be superimposed on the first one? And we always have in mind Article 69 of the European Patent Convention, which says that the extent of the protection conferred by a European patent shall be determined by the claims. And nothing but the claims, I add myself. Nevertheless, the description in the drawing shall be used to interpret the claims. So the claim is what matters, and the description and the drawings are only for interpretation of the claims. And having this in mind, we do not think that there is enough in claim 1 or 2 that is requiring that the second overlay is superimposed on the first one. We have in mind, of course, that there is one example that is showing this, but this is just an example, nothing more in our interpretation. And on the background of this interpretation, and based on what Mr. Holzer has said on the novelty with regard to the Hennig application, there is one missing link, which is not disclosed in the Hennig application. That is the requirement that the second overlay is on the request of the user displayed on the monitor, on the request of the user. However, the Hennig application is showing that information on the following channel is giving on the request of the user. This is not the same, this is the same overlay, it's not the second overlay. However, we tend to follow the argumentation of Mr. Véran that it has been obvious for a person skilled in the art to say, okay, if I have this additional information on the second, this further information in one overlay, then it is obvious for a person skilled in the art to have this also in a separate second overlay. And on this basis, we come to the conclusion that the patent is not valid because it was obvious to the person skilled in the art. And this has a good result. We do not have to decide on infringement with regard to this, but however, there's still the French part missing, and there Mrs. Girardet wants to add.
Just another question, but and maybe the last one, is the scope of the revocation. Because the revocation, what about the French part of the patent? It seems to me that it's a counterclaim. It's a counterclaim. So if we consider that the claimant is inadmissible to sue on the basis of the French part of the patents. As a consequence, the scope of the revocation doesn't take into account, doesn't accept to the, I'm looking for my words, the French part of the brevet. So the French part of the brevet will keep on being valid in my point of view, but it may be a question of discussion to our days.
And you have good chances in a second try to destroy it.
If it remains, then there is no infringement.
Yeah,
Maybe the court will be interested to know the decision rendered by the audience. Regarding, you have the list, I think, in front of you, so I will not repeat the question, but just mention regarding the stay, the first question, the response was no decision of stay. Regarding the question 2, the response was yes. Regarding the question 3, the response was yes. Regarding the question 4, the response was no. No for question 5, no for question 6, yes for question 7, no for question 8, no for question 9, no for question 10, yes for question 11, no for question 12, and no and yes for question 14. Here we are.
Almost perfect harmony, I think.
Except the infringement. Except the infringement. Maybe the president will be happy to say a few words to end this fantastic trial.
Not a conclusion, but talking to the audience in the auditorium and also to the people on the net, I hope you enjoyed. The purpose was to learn. I think I've been learning many things, including the first one that I know nothing about that, but knowing that you don't know is a good start if you listen to Socrates. This has been possible because there was this panel and an incredible amount of work. You have to be conscious of that. And I say that because we'll be looking for candidates for the next mock trial. So this is a lot of work. So thank you to all of you. Thank you to the panel of judges. Thank you, President Girardet. It was a real... It was a real pleasure. It was a real pleasure to see you back in the Patent Court. Thank you to Mr. Grabinski. You have to understand that Mr. Grabinski plays a major role in all this story. We have seen each other in so many places, talking sometimes with a lot of energy about these issues. I remember a meeting in Poland, which was a hot one. Thank you to Walter, while you are part of us. It was good for we French to discover a technical judge. This is something we have been asking for a long time, so very good. And thank you to Michael. We see that Switzerland is not part of Europe, but Australia is close, so it's good. Thank you to Pierre Véron and Amandine. Thank you very much for your work. And for all the work you did in preparing the case. Thank you for our registrars and to Julie's deputy and you were also, apart from the work that you did, an excellent master of ceremony. Thank you very much. And if I may just add 1%, it would be Sabine Ager, because she has done so much work. Thank you very much. Thank you to our sponsors, of course, and I hope they will remain sponsors for the future. Now there is a difference between the auditorium and the net. is that technique does not allow us to share bubbles of champagne, so I will invite you to go and share some champagne with us, and goodbye to our net friends. Thank you.